the second half of a traffic stop. Most people think of traffic stops as simple. Lights flash, a window rolls down, a few words are exchanged, and everyone moves on. But for millions of drivers, there is a second part of the stop they never expect. It begins when the officer asks them to step out of the car. That moment changes everything. The legal stakes go up, the level of officer control goes up, and the driver's confusion goes up. It is where simple misunderstandings turn into arrests, vehicle searches, and court dates. Lawyers and legal analysts who watch roadside encounters say that this is one of the most misunderstood parts of Fourth Amendment law. Drivers assume they have the right to stay seated. Officers assume their commands will be followed. Both assumptions collide at the roadside, and what happens next is shaped not by opinion but by Supreme Court precedent. Understanding that precedent does not mean arguing with officers or trying to win a traffic stop. It means staying calm, communicating clearly, and preserving your rights for the place they are meant to be argued. A courtroom, not a shoulder on the highway. Section 1. A simple stop. Traffic stops usually begin with something minor. A broken taillight, a plate that expired last month, a missed signal. What most drivers do not realize is that once those flashing lights activate and the stop becomes lawful, a chain of legal authorities is triggered. One of those authorities is the power to ask, and sometimes order, the driver to exit the vehicle. Legal scholars point out that this is the first moment where confusion and escalation appear. Drivers assume they have the right to remain seated unless accused of a serious crime, but the law does not work that way. The Supreme Court's interpretation of traffic stops treats them as potentially hazardous encounters where officers are responsible for managing the scene. That management can include removing drivers or passengers from the vehicle for safety reasons. The tension is not about guilt or innocence. It is about who controls the environment. Key takeaways. Traffic stops activate legal authorities that most drivers do not know exist. Exit orders are based on scene control, not on criminal suspicion. Early confusion is one of the main reasons that escalations stop. Section 2. The case that changed it. The modern rule comes from a Supreme Court decision in 1977, in a case called Pennsylvania versus Mims. The facts were simple. A Philadelphia driver was pulled over for expired registration. During the stop, the officer instructed him to step out. When he did, a concealed firearm became visible under his jacket. He was arrested and later argued that the order to exit had nothing to do with the traffic violation and therefore violated the Fourth Amendment. The Supreme Court disagreed. In an 8-1 ruling, the court held that once a stop is lawful, ordering a driver out of the car is also lawful. The justices reasoned that officer safety outweighed what they called a minimal intrusion on the driver. Studies at the time showed that approaching seated drivers posed risks and unpredictability that the government had a legitimate interest in mitigating. That analysis became the foundation of roadside exit authority across the United States. Key takeaways. Pennsylvania versus Mims, 1977, authorized exit orders during lawful stops. The court prioritized officer safety over driver inconvenience. The ruling applies broadly, not just to serious or criminal stops. Section 3. Passengers included. For nearly 20 years, the Mims ruling applied mainly to drivers. Then, in 1997, the Supreme Court expanded the rule in Maryland versus Wilson. That case involved a routine traffic stop where the officer asked a nervous passenger to step out. The passenger complied, and drugs were discovered during the encounter. He challenged the instruction, arguing that innocent passengers should not be subjected to exit orders without suspicion. Once again, the court sided with officer safety. Passengers, too, could be ordered out during any lawful stop, regardless of whether they were accused of wrongdoing. The court described traffic stops as especially fraught with danger and held that managing all occupants of the vehicle reduced risks during roadside encounters. Today, the combination of Mims and Wilson means that both the person behind the wheel and the person sitting beside them can be ordered out without individualized suspicion. Key takeaways. Maryland versus Wilson, 1997, extended exit authority to passengers. Innocence or non-involvement does not limit the rule. Modern exit orders apply to everyone inside the vehicle. Section 4, request or order. This is where real-world experience becomes complicated. Officers do not always begin with direct commands. They often start with softer language. Can you step out for a moment? Or, would you mind stepping out so we can talk? That sounds voluntary. Sometimes it is, sometimes it is not. A request can be declined without legal penalty. An order must be obeyed once the stop is lawful. But roadside communication is stressful, fast, and full of assumptions. Drivers may decline an order believing it was a request. Officers may believe their order was understood, And once confusion enters the picture, escalation tends to follow. Legal professionals recommend clarity, not confrontation. Asking whether the officer is requesting or ordering removes ambiguity. It also clarifies the record on body cameras, which courts later rely on when reconstructing what happened and why. Key takeaways: requests are voluntary, orders are mandatory. Language during stops can be intentionally soft to reduce tension. Clear communication prevents escalation and preserves legal clarity. Section 5. When refusal backfires. Once an exit order is lawful and unambiguous, refusing to comply can escalate the stop instantly. Officers interpret refusal as interference or obstruction. Courts often uphold arrests in those situations, not because of the original violation, but because of the refusal to obey a lawful command. This is how small infractions turn into bigger problems. A broken tail light can become an obstruction charge. A speeding ticket can lead to arrest. And once an arrest enters the scenario, additional legal authorities activate. For example, a search incident to arrest can allow officers to search the person and sometimes the vehicle as part of the custodial process. What began as confusion became a criminal case. Lawyers emphasize that the roadside is never the place to litigate constitutional rights. Disputes belong in court, where evidence, body camera footage, and legal arguments matter. Key takeaways: refusing lawful exit orders can lead to arrest and additional charges. Arrest triggers new legal authorities, including possible searches. Roadside arguments rarely help drivers and often harm their case. Section 6. Exit isn't search. One of the most common misconceptions among drivers is the belief that an exit order automatically allows a search. Courts consistently reject that idea. The legal authority to remove someone from a vehicle comes from safety, not suspicion. Those are two different branches of Fourth Amendment law, and confusing them leads to mistakes on the roadside. Under Terry v. Ohio, 1968, an officer can pat down a person only if there is reasonable suspicion that the person is armed and dangerous. Under the automobile exception to the Fourth Amendment, a vehicle can be searched without a warrant only if officers have probable cause to believe it contains evidence of a crime. Neither of those requirements disappears because the driver stepped out of the car under Mims or Wilson. Where drivers get into trouble is through consent. Consent to search bypasses the need for suspicion entirely. It is one of the strongest permissions a person can grant during a traffic stop. What looks like cooperation in the moment can later become the legal foundation for a search that would not have been permitted otherwise. Attorneys often say that the Fourth Amendment is strongest when people know how to avoid accidentally waiving it. That principle applies more to vehicle searches than almost any other area of constitutional law. Key takeaways: exit authority is based on safety, not suspicion. Searches require probable cause, reasonable suspicion, or consent. Consent is a major factor in vehicle searches and often misunderstood by drivers. Section 7. The body camera era. Before body cameras became standard, traffic stop disputes often came down to competing stories. Officers said one thing happened, drivers said another, and courts had limited evidence to evaluate. That changed with the widespread adoption of dash and body cams. Today, what a driver says, how they behave, whether an instruction was a request or an order, and how clearly each side communicated is often recorded in real time. That footage becomes evidence later. Judges analyze tone, clarity, compliance, and sequence. Lawyers replay frames and audio to reconstruct what happened second by second. In many cases, body camera footage becomes the most objective witness in the courtroom. For drivers, this means clarity and calm behavior are strategic, not just polite. A simple statement such as, "I'm complying with your order," helps courts distinguish voluntary actions from compelled ones. Likewise, clearly declining a request without hostility can make the difference between consent and non-consent in a legal analysis. In the body camera era, how you communicate can matter as much as what you communicate. Key takeaways: body camera footage has transformed traffic stop litigation. Calm, clear communication benefits drivers during legal review. Courts often rely on video, not memory, to determine what happened. Section 8. Silence and questions. Traffic stops are filled with small talk that feels mandatory but often is not. Questions like, "Where are you headed?" or "Where are you coming from?" are routine. Legally, drivers do not have to provide narratives or explanations that go beyond identification and license status. The Supreme Court addressed questioning during traffic stops in Rodriguez v. United States, 2015, ruling that officers cannot extend a stop beyond its mission, such as issuing a ticket without independent justification. Silence, however, can feel awkward in the moment. Drivers often answer reflexively to avoid appearing uncooperative. Legal analysts note that roadside conversation tends to expand into areas that create risk. A statement intended as harmless can later become the thread that leads to more questioning, passenger questioning, or calls for canine units. Exercising the right to remain silent does not have to be confrontational. It can be as simple as acknowledging the officer's authority while declining to elaborate. In legal terms, silence protects drivers from self-incrimination and unintended disclosures that might expand the scope of the stop. Key takeaways. Routine questions during stops are optional in most situations. Rodriguez, 2015, limits the expansion of traffic stops without justification. Silence is a constitutional right and can protect against escalation. Section 9. When duration matters. Time plays a major role in the legality of traffic stops. A stop that begins lawfully can become unlawful if prolonged beyond its original purpose without an independent cause. In Illinois v. Caballe, 2005, the court held that using drug-sniffing dogs during a lawful stop did not violate the Fourth Amendment as long as it did not unreasonably extend the duration of the stop. Rodriguez later clarified that extension for dog sniffs or unrelated investigations requires separate justification. Duration matters because it defines what police can do without changing the legal category of the encounter. Officers may check registration, verify identity, confirm insurance, and write warnings or tickets. Once those tasks are complete, the legal justification for the stop begins to dissolve unless new suspicion arises. For drivers, understanding timing prevents confusion. Many roadside disputes begin when drivers believe they should be free to leave but do not ask. A simple question, "Am I being detained or am I free to go?" helps distinguish completion from continuation without confrontation or escalation. Key takeaways. Traffic stops cannot be prolonged without independent justification. Caballes, 2005, and Rodriguez, 2015, define how duration is analyzed. Clarifying detention status prevents confusion and protects rights. Section 10. Court versus Roadside. Lawyers consistently warn against trying to argue constitutional rights during the stop itself. The roadside is not designed for legal debate. The environment is tense, fast, and influenced by safety concerns. The courtroom is the opposite, structured, deliberate, and guided by rules of evidence. Attempts to resolve legal disagreements on the shoulder of a highway often produce the opposite of what drivers intend. Escalation leads to charges. Charges lead to court. And by the time the matter reaches a judge, the body camera footage becomes the central narrative. What drivers thought was advocacy often becomes evidence. The place to challenge unlawful detention, improper search, or constitutional violation is the legal system, not the asphalt. Judges suppress evidence, lawyers litigate, juries evaluate. The roadside is meant for safety, clarity, and compliance, not adjudication. Key takeaways. Constitutional disputes are resolved in court, not during the stop. Roadside arguments often become evidence rather than defense. Compliance preserves safety and preserves issues for litigation. Knowledge is leverage. Understanding exit orders does not mean arguing with officers, refusing instructions, or trying to win a traffic stop. It means recognizing that traffic stops are legal events shaped by Supreme Court precedent, officer safety considerations, and Fourth Amendment doctrine. Knowing the difference between requests and orders, consent and silence, safety and suspicion does not guarantee outcomes, but it reduces the risk of escalation and preserves your rights where they matter most. The modern approach to traffic stops is not about confrontation. It is about communication. Calm answers, clear questions, and non-aggressive conduct help body cameras capture facts rather than conflict. And when disputes arise, those facts become the foundation of legal analysis in front of judges, not officers. If content like this helps you understand how the law works in the real world, consider subscribing to more breakdowns of cases, rulings, and legal strategies that affect everyday people. Information is not just power in the courtroom. It is leverage during ordinary encounters that happen to millions of drivers across the country every year.